So first, let me make a few observations based upon what we've heard. It seems clear that there's a general consensus here that if classification is meant to prohibit the disclosure or publication of classified information, if that's what the concept of classification is supposed to mean, then we vastly overclassify. That for the different reasons that have been suggested, that one problem we face is that we classify huge amounts of material that in fact needn't be kept published, secret, and that even people like Gabe have published, despite the fact that it's classified, and despite the fact that it's illegal to publish classified information. So what that breeds is a kind of cynicism and dysfunction about the whole enterprise of government secrecy. So one issue that I think clearly should be addressed if we want to have a more effective and more credible and to enforce, despite Judge Posner's skepticism that that would work, exactly what can be classified and for what reasons and subject to what degree of review internally to ensure that we're only classifying those things that we really believe should be kept secret. And that would eliminate a vast amount of the classification that currently exists. But that would still leave the question, of course, of what is it that should be classified. And I think Gabe argues that information that would be harmful to the national security should be classified and anyone who discloses it should be punished, and anyone who publishes the information should be punished. Now, I would raise a question there, because it's interesting, Gabe, that you rely upon the cry of fire in a crowded theater hypothetical, because you misquote it in a way that's profoundly important, right? Holmes's hypothetical was that it was punishable falsely to yell fire in a crowded theater. And that's very important to the power of the hypothetical. Because if somebody truthfully yells fire in a crowded theater, we would, of course, not think for a moment of punishing that person.
That's not true.
What's not true?
Because you can cause as serious a panic when there is a fire as when there isn't a fire.
That's the point, though. That's exactly the point. We would not punish someone.
No, you don't understand. If you shout fire in a crowded room with limited exits, even though there is a fire, the panic that ensues from your having cried fire may be more serious.
And we would never punish someone who truthfully yelled fire in that situation. No, we would not. No, we would not.
And what does that show? That we have
what it shows us is that the power of the hypothetical.
You're missing.
No, wait. No, wait. The reason Holmes said false is because that was a situation where the speech itself was valueless. It did not contribute to anything. And therefore, it could be punished in those circumstances. But if the speech is true, it's a completely different problem. And you may have situations, which Dick points out, you may have a situation where the speech is conceivably punishable. But that would be a case in which you'd have to make a judgment about whether the value of the speech was outweighed by the harm that's caused. Right, Dick?
You can't. I mean, that's...
You wouldn't
make a judgment like that.
Dick, would you make it a crime for anyone to truthfully yell fire in a crowded theater in all circumstances? Is that what you're saying? That would be ludicrous.
No, I would say if
I'd love debating with Dick.
Negligent. There are circumstances in which crying fire. When you've seen a fire and you start screaming fire, it's a fire in a wastepaper basket. It's harmless. You're screaming fire. And you cause a panic, and people are trampled.
Right. So
you can't punish that person?
No, that's not what I said. My point is that when it's a fault, the hypothetical is that the speech is valueless. No, Dick.
Anyway, you've overstepped your bounds as moderator.
No, I haven't.
You're not moderating. I have important points that I want to make.
Dick,
I don't want to talk about your
Dick,
fire in the basket.
Go argue with your district court judge. I just want to finish the point, and then I'll be happy to turn it over to my colleague and others. the key point is this, and it's fundamental to this issue, right? When the government says we want to punish speech because it's harmful, but not valueless, you have to weigh the value against the harm. And that's true in the true cry of fire. In the true cry of fire, you might be willing to punish the speaker, but it will be because you decide in that case it was reckless to say true because the harm was great and the value of warning people was trivial. Unlike the false cry of fire, which you'll punish because it's valueless. What that means is the mere fact that speech is harmful, Dick, shut up.
Are you going to carry on for the rest of the session? You're supposed to be the moderator.
Dick, come on.
You tell people how terrific the panel is, and then you shut up.
If you'd let me finish the point, then there'd be no problem.
Let's get away from the fires.
Okay.
Talk about
Okay, Gabe.
I'll talk about national security secrecy.
Go ahead.
The question of harm. Let's just take an example I think we can all agree on, that the publication of the identities of undercover CIA officers can cause harm to those people, and Congress acted to make that illegal, to publish those names. So that, I think, is equivalent, to return to the fire for a second, to falsely yelling fire.
But it's truthful.
It's truthful.
Talk about false. Okay,
let's put the fires aside. I should have followed that. So I would make the case that we're a country of laws, and this is a case where the press should be prosecuted.
Judy?
Okay, I want to argue against my friend Gabe. We've been having this debate for a long time as well. Just in terms of the facts with respect to Julian Assange, WikiLeaks, and what they've published, and what our legal history is, and here I'm venturing into terrible territory because I'm not a lawyer, which would be even more unpopular than being a journalist. But let's just, in terms of classified information, since 9/11, there are 60 new categories of classified information. So if you think that we live in a more open and transparent society than we did before 9/11, that's wrong. Two, going after a journalist for publishing would be a radical new step. What happened with the Pentagon Papers, which was a move to stop the New York Times from publishing information that it wanted to publish that was classified, was that the Supreme Court weighed whether or not the damage to national security would be outweighed by the infringement on the First Amendment. And Justice Stewart said that the government would have to prove direct, immediate, and irreparable damage to our nation or its people. Now, both the Justice Department and the Pentagon have conducted studies of the damage that Julian Assange and WikiLeaks have done to our national security. Neither of them has disclosed the results of those studies. Now, why do you think that is? Because it's, I hate to go back to the wastebasket and the fire, but you know what I'm saying. So the fact that they cannot prove or have not been willing to make a case that there is such damage should give us great pause before we start to criminalize the publication of information. Finally, there are ways, informal ways, in which news organizations and the government deal with these issues every day. And you don't read about them, but except when things go to court or there are fights about them, but it's called the New York Times reporter or the Washington Post reporter or the Fox News reporter calls up and says to the White House, I would like a comment on the story we're going to publish, and it's really, really going to make you angry, or in Judge Posner's case, embarrassed. And the White House says, whoa, no you don't. Let's talk about this. And you have discussions going on every week about the publication of this kind of information. The White House has an opportunity to make a case that its publication would jeopardize national security. Most often, papers, dirty little secret, do not publish that information. They wind up withholding information, as the New York Times has again and again and again. But this is the system that we've devised to get around what would be the prosecution of people for doing our jobs, which is letting you know what's going on in your government when they're leaking all the time the stuff they want you to know and withholding the stuff they don't want you to know.
I'd like to make 2 points. I want to take issue with something that Judith said, but it's really to complain about lack of evidence. So she says, I'm sure correctly, that more and more documents are being classified. Yes, but of course the government is growing in size and publication is growing. So my question for you is the percentage of classification of government documents increasing? That's number one. Number two, what about the increase in leaking, right? What if the amount of leaking is increasing at a faster rate than the amount of classification, right? Okay, that's the first one. Second point relates to the fire.
I'm glad I didn't have you as a teacher.
The second point is, look, Jeff says you want to balance the value of information against the harm to national security. No, you don't want to do that because it is totally formless analysis. It's impossible. You're going to do it case by case. The dilemma is that on the one hand, we could be like Britain and we could have an Official Secrets Act which says if you reveal classified information, that's a crime. We could do that. It would be a little silly because of the vast overclassification. The alternative is somehow, which most of these laws do, is somehow to build into the law, the crime, some notion of harm. But when you do that, you make it very difficult for the government to prosecute even when it has a really good case, because the harm, to explain the harm to a jury may require disclosing secrets, right? So that it doesn't work. You can't do it that way. Look, there are a lot of problems in our society that cannot be solved. This problem cannot be solved. So we have a struggle between the bureaucrats desperately trying to keep secrets and the hackers and the journalists and the media and YouTube and everybody trying to reveal secrets, right? I think that's the best. I think that's the best we can do. Now, maybe we could somehow identify just the area in which people are endangered by a revelation. I mean, you'd obviously want to protect the sort of physical safety of people. Maybe that could be some very narrow category of punishable activity. But I'd say, given the incentives of everybody, the journalists, the bureaucrats, the leakers, the hackers, I don't think much progress can be made. And as I said, I don't think it's that important.
So, Dick, what would you do with Gabe's hypothetical?
Well, he gave an example of where American troops are being endangered because their jamming equipment is being revealed. That seems to me an endangerment. You're endangering human lives. There are lives. So yeah, I don't have any objection to that. On the other hand, when the danger in all, the lawyers are always going to struggle to expand these categories. So it becomes possible to argue in almost any case that this leak will lead somewhere down the road to someone will lose his life, right? So you can't deal with that. Judith quoted Justice Stewart saying, you can only prevent publication if there's a direct, immediate harm. Well, that doesn't make any sense, right? If the country is going to be destroyed by some ticking time bomb in 3 years rather than tomorrow, does that mean, well, it's not immediate? We can't do anything about that, right? So the categories the judges try to impose on this really unmanageable material are just inadequate.
Well, I would also take issue with Judith. The Pentagon Papers case came to the court as a prior restraint case, not a case of prosecution of the times for after the fact for having published these secrets. And I believe it was 5 of the 9 justices said that if information came to them after the fact as a prosecution rather than a prior restraint, which demands this very, very strict standard, that they would consider convicting the Times under the espionage statutes.
But the government didn't bring that
course
case.
not.
The government did bring that.
Never brought that case. And if it starts now, where are we going?
I think the country is very fortunate that we've never had a prosecution, and I'm glad that in that case, I think they would have had a great difficulty bringing that case in New York City, and the federal district prosecutor in the area declined to bring it for that reason. But the Chicago Tribune case is, I think, a classic example where we really would, I think, I'd be interested to hear your views, whether you would like to see a newspaper publisher who's intent upon publishing a story that could kill thousands of American servicemen should go to prison or not.
I think, once again, the government decided it didn't want to bring the case, that bringing the case would generate more publicity for that information than it wanted to. I think in time of war...
Why don't you say yes, right?
Because that raises a slippery slope. I want to take a position on the other side because I'm a journalist. And I want to air...
Example of the
even
code
look,
breaking?
I have no problem with the government cracking down on Bradley Manning. He took an oath. He disclosed classified information. I submit that there's a difference between someone who has taken that oath not to disclose classified information and leaks it. I have no trouble with the government prosecuting him. I have trouble with you prosecuting the Washington Post for publishing it. Judy, there's a difference.
Judy, the laws are on the books. If you disagree with the law, work to change it. Don't violate it.
I've been doing that for the past 5 years, but unfortunately I need a president who's going to uphold the promises he made when he was
Two points I want to add here. One is that I think that you keep saying the laws are on the books, but that's not an answer to anything in a world that has a constitutional law. Right? The argument is whether the laws on the books are constitutional. Now, however cynical one might be about how the courts interpret the Constitution, the fact that they're on the books is not an answer to anything.
Well, I would make the case that some of the laws on the books are constitutional. The Espionage Act. The Espionage Act. I would make that argument, and we could spell it out here and go into some depth. The Espionage Act itself, I think, is problematic. It's never been used for prosecuting the press, and I think we would run into serious constitutional issues. But the Comint Act is, I mean. It's a model of clarity, and
okay.
I mean the statutes here they protect narrow categories of information, and precisely the kind that could get lots of people killed. I think that's a good direction for the United States.
So let's talk about this question about harm to American soldiers, let's say. So suppose the New York Times reveals the fact that there's been torture at Abu Ghraib, and the government argues that will lead that will endanger American soldiers because the enemy will be furious at the fact that we've been torturing them, and that if they capture American soldiers, they will be more likely to torture them in worse ways than they ever otherwise would have done. And therefore, the government wants to punish the disclosure of the fact that Abu Ghraib occurred. Under your theory, you'd have to allow that punishment?
No, because we don't have a law that protects that kind of information from publication. I would be opposed to such a law that was very general like that. I think that such a law would be dangerous to our liberties. But I am for narrow laws that protect narrow categories of information.
So, but what's the distinction between that, which says no one may publish information that will lead to the consequence of endangering the life or safety of American soldiers? That's the law.
Jeff, when the enemy learns that we torture their prisoners, they'll back off, right? They'll be scared. Say the Americans, oh, we thought they were pussycats. Pull our ears out.
To them, but we're not revealing it to them.
No, we have other audiences. Look, I'll give Judith, all right, this is your last chance, Judith, to redeem yourself for reasonableness. Okay, suppose May 1944, the New York Times publishes an article saying, hey, we've learned that on June 5th, the United States and Britain are going to invade northern France, D-Day. The Germans think, and the Americans and British have been trying to get them to think, that the attack will be in Calais. And as a result, the Germans have moved their armored divisions to Calais. Actually, the attack is going to be in Normandy, where the Germans are not expecting it. Okay? You think this is not punishable?
Cuban Missile Crisis.
Question? I'll say to you what I say to lawyers in my court. If a question can be answered yes or no, you answer it yes or no, then you explain your answer, right? I gave you a clear case.
Okay, the answer would be yes, you can punish them, because, as Judy said in the Pentagon Papers case, the court recognized that if there is clear, immediate, and grave harm, then you can punish the speech.
But I asked Judith, right? It's as if I ask a lawyer a question, yes or no,
Right,
and the
I'm
lawyer
deferring
from the
to
other
my
side
lawyer.
answers.
I recognized a long time ago that it's very dangerous to go into our legal system here or a debate without a good lawyer.
You think it should be punishable conduct?
Agree with that result.
I agree with the result.
Okay. Well,
But here we go. You know, we had, if we think back to the Cuban Missile Crisis once again. John F. Kennedy afterwards said the New York Times did exactly what you suggested it not do in 1944. You know, it did not publish the information at the request of the government. And afterwards, President Bay of Pigs, John F. Kennedy said he wished that we had done so. You know, on balance, eventually, obviously, at times we're going to get things wrong. The press is going to publish something that it shouldn't be publishing. Like, for example, Gabe, I would agree with you. The swift information about how we're tracking the money of terrorists, and I've been following terrorists for before it became fashionable. That was very damaging. It made it harder for the U.S. government to track that information. However, we are going to get things wrong, but on balance, you don't want the government making the decisions about what can and cannot be published. That's not...
But there were no Americans endangered by the Bay of Pigs invasion, just Cubans, right?
Judith, we live...
So it was easy for Kennedy to say, yeah, wow, we could have written off those Cubans, right?
We live under a system of laws. The press does not get to decide when it can violate the law or when it can observe the law. It's obliged to follow the law. Unless you're taking the position that the press is engaging in civil disobedience, which is a noble position.
That is what I did. I decided to go to jail because the law said that I had to testify before the grand jury, and I knew that my journalistic obligation to the source, in my mind, took precedence, and so I was willing to go to jail. But why invent laws that are going to make it easier for the government to keep information from the public that the public ought to have?
Well, the public, in your case, the public was investigating a crime.
No, a prosecutor who I believe has some relationship to Chicago was actually arguing that he was investigating a leak under a statute that you cited, but then it turned out that wasn't what he was investigating at all. And the investigation under the Agents Identities Act turned into something else. It turned into a perjury investigation.
But the point is, Judith,
these things start, and the government is very powerful, and it needs checks on its power.
The point is that the Congress has repeatedly declined. That is the American people have repeatedly declined to enact. The Congress represents. The Congress is the American people. It has repeatedly declined to enact the kind of statute that you favor.
You shouldn't say things like that.
Go on. You want to elaborate?
Congress is the American
people. We live in a democracy, Judge Posner, and that's the best we have. Of course, it doesn't reflect the will of each and every one of us. But
each and every often doesn't represent the will of anyone but a handful of special interest people and lobbyists, right? Be realistic about what democracy means.
I'm fully realistic, but
You're not realistic when you say things like Congress is the American people. You know what democracy is? Democracy is a system where people get to throw out officials in periodic elections. That's what it is. It doesn't mean that legislation reflects the popular will.
Well, I'm somewhat less cynical about American democracy than you are.
All right, I'm cynical.
That will open it up to the floor. Yes, the very persistent man over here. Yes, there's the microphones. You'll have to. And keep these should be questions, not speeches.
Okay. First, I want to continue on Judge Posner's comment. Does it matter? Does it matter? Of course it matters a whole lot. This is democracy that we live in. So I'd like to now address Judith Miller, and first thank you for coming. And I'd like to ask you, in a free press, democratic society, to what extent you believe it's a journalist's responsibility to report accurate and precise information to the American Republic. And nested within that is the question of to what extent you believe working closely with the incumbent regime to rely on the Bush administration specifically.
Thank you. That's enough.
Yeah,
we got your question.
Affiliated with the Bush administration,
sir,
is that appropriate or not?
Sir, thank you.
Thank you very much.
Who wants to go first?
Thank you.
I'll just say this about dealing in national security reporting is that every person I talk to, or most of the people I have to get information from, are people who have to take polygraphs every 6 months for a living. And when they feel strongly about something, strongly enough to talk to me, even though they know that the first question in every polygraph is, have you had any unauthorized conversations with a journalist? I think this is a very difficult area in which to work. And you go with the information you have, you try and check it out as best you can. You hope that people who disagree with what you're being told will come forward and say that. And you hope they'll attach their names to it, since many publications have rules against anonymous sources, which mine did, my former publication did. And you do the best you can. This is not science. It's very difficult. You get stuff wrong. Everybody gets stuff wrong. But on the WMD issue that you raise, I think what I was reporting reflected accurately what the intelligence community believed at the time, or at least what the president was told they believed. And we have to do a better job, us as journalists and the intelligence community as a whole, at getting it right. And I think that the publication of information like this helps them get it right. And that's why I'm still doing it. Thank you.
Questions? Yes, Senator here.
A few years ago, Prince Harry was sent to fight in Afghanistan. The British press embargoed the story based on the fact that they felt there was clear and present danger to him, a special kind of a danger. But he was outed by Matt Drudge in the Drudge Report here. If you had jurisdiction, I'd like to hear somebody theorize about what your conclusion would be.
Well, I don't see any special law in the books that would protect an American prince from having. I would support a law that would protect the identities of intelligence agents. I think we've seen the damage that can result when their names are inadvertently or purposefully disclosed. The British have their own methods. An interesting counterpoint to your case, though, is the case of David Rode, who was a New York Times correspondent who was kidnapped by the Taliban. And the Times not only kept this secret from the public for a period of 6 months, but managed to get every other newspaper and every blogger in the country to keep it secret, and only revealed the information when Rode escaped his captors and made his way to safety. So when the lives of journalists are on the line, the papers are very careful. When the lives of Americans are on the line, they're not quite always as careful. Other Americans.
Judge Diane Wood?
Yes, I just wanted to say, I'd be interested to know where the panel comes out in this choice, because on the one hand, you can have very broad laws that are enforced a tiny amount of the time, which is in a sense changing from the rule of law to the rule, if you will, of men, prosecutors just deciding. On the other hand, you have this trust us, we're journalists system, which might be fine if it's just the New York Times and the Washington Post, but today it's everybody who feels like creating a blog. Which evil are we going to go with? Because I don't see where the middle ground is.
Well, as for me, because I'm a journalist, this is an excellent question, but I think I side with Thomas Jefferson. If you have to choose between, having a government without the press or a press without government, you go with a government with a free press. I mean, it's a balance. Everything's a balance, and I think we're still around. We're still a democracy. There have been many, many challenges, and we've come out of them safer than we were before 9/11, and freer, though less open.
The general answer in criminal law to the question is criminal statutes are generally overbroad. They're vague because of the concern with loopholes, right? And then a great deal, enormous amount is left to prosecutorial discretion. And I think probably that's inevitably the case. What makes it so serious, what makes it a really serious, but I think insoluble problem, is that the amount of classified information is so vastly greater than the amount that should properly be withheld from the public, that and prosecutors have mysterious motives, and there are all sorts of political concerns, that it's very dangerous to have these very broad laws which can hit people. Even an unsuccessful prosecution is very costly and creates a lot of anxiety. On the other hand, as I said, if you define these laws narrowly, you make it very difficult to prosecute, because it's often difficult to reveal the reason why this is a harmful revelation without disclosing more information about your secret activities. So I don't think there's a good solution. I think we have a multiplicity of laws, and leaks that involve electronic transmissions are punished much more severely than others. It might be possible to consolidate the laws, make them a little narrower and somewhat clearer. That's all I could recommend.
Well, I would also note that we have largely a system of prosecutorial discretion here, and the prosecutions have been very, very rare. It's the Obama administration who's really the first administration to employ the Espionage Act and the other acts in a very, very vigorous way. But for the preceding hundreds of years of American history, or since the Espionage Act was passed in 1917, I think there were a total of 3 prosecutions in all of our history before the Obama administration. Now, an administration that has pledged to be the most transparent in all of American history has somehow become the most Nixonian. And that's ironic, but I think the prosecutors have acted fairly wisely and with restraint in most of the cases. We have a system which, after all, does operate with just a torrent of leaks, but very rarely result in prosecutions.
I would only say one more thing about the classification issue, and that is that the Washington Post, which is one of the few papers that can still afford to do investigative reporting, which is very expensive and very dangerous, in part because you have to hire so many lawyers. But they tried looking at this issue that the judge raised about, are we classifying more? How many people have top security clearances? How many documents are classified? And after 2 years of work, they couldn't come up with a figure on how much our country was spending on national security, protecting national security. And it did find, however, that now we have over 1 million people in this country who have top security clearances, and they're the ones who do a lot of the classifying. And I think this is a huge problem, and unfortunately I agree with Richard Posner. It doesn't have an obvious solution.
There's a bit of conventional wisdom setting in here about overclassification, and while I agree that it's rampant, we shouldn't take these mushrooming numbers at face value. I mean, after all, after September 11th, it became clear that we had to impose secrecy on a whole sets of categories that we'd never considered before, largely of technical characteristics of objects and of just bridges and buildings, things like that we wanted to protect. A lot of the
public safety meetings on nuclear reactors.
Obviously, there's also been some excesses, and for all the bureaucratic pressures that you and Judge Posner mentioned, and I also agree with Judge Posner, this is not a solvable problem. So I think that our search for balance has to look in another direction rather than finding a way to stanch that particular problem.
But you're frightening because you're saying before 9/11, all these bridges that were about to fall down, well, maybe we knew about it, but now all this decrepit infrastructure is now classified, right?
Well, I think it would. I mean, there, you know, like things like the path tunnels that connect New Jersey to New York. There were vulnerabilities there that were lying in plain sight, and those
they're
were
still
well,
there. Now
the study, the actual documents and blueprints.
It sounds like a joke, right? Because what you're saying is, all of a sudden, someone who asks about the tunnels under the Hudson River, or the Hudson River is told, oh, no, this is classified because of vulnerabilities, right? So now you know, well, if I want to attack, I'll attack one of these classified civilian structures, right? I mean, this is an absurd world, really.
I just want to say that the idea that this is an insoluble problem is not helpful. There is a solution, whether it's a good one or bad one is the problem. The reality is, if we don't do anything, the solution will be wild overclassification, arbitrary prosecutions of individuals who have embarrassed the administration, punishment of whistleblowers, imprisonment of reporters, whenever it's convenient for any particular administration to do so. That will be the solution. Right. And the question that's really posed by this is that an acceptable solution? And if not, what's a better one? Well, let's go back to the audience then.
Well, I really had a question that...
Where are you? We can't see.
Okay. This one was really almost answered just now with Jeff's comment, but you, at least three, maybe all of you agree that we do suffer from a vast overclassification. What kinds of carrots and sticks can you imagine we could bring in to bring the level of the amount of material that gets classified down to a reasonable, workable level? What can we do to change things?
Well, there are a number of reforms that have perennially advanced, like limiting the number of people who have access to the classification stamp and making them write explanations of why they're classifying particular pieces of information. And these things have all been tried over the years, but the bureaucracy has a way of overcoming everything and finding new ways to get around these procedures, because there are a lot of incentives to classify that have been mentioned. But if you get something wrong, if you make it public and it's embarrassing, there goes your job, your promotion, your benefits. Or if people get killed, even worse.
Steve, you gave that, okay.
If in this country the rule of law was set in stone, as I thought I heard Mr. Schoenfeld indicate, wouldn't we still be subject of the English monarchy, and wouldn't we still have Jim Crow as the law of the land in the South, and wouldn't we still be mired in Vietnam?
The law of the land was set in stone, but the law of the land is not set in stone. We live in a representative democracy that changes the laws in response to things like elections. So things evolve. We got out of Vietnam under popular pressure. So I don't know. I don't think we'd be living under a monarchy, to be short.
I'm handing out. You handing out the microphone?
Yes, there's another person as well.
Okay. Where?
Mrs. Miller? Miss Miller? Here? Since you've expressed your ultimate displeasure with President Obama and his relationship with WikiLeaks, since we're stuck with Obama for 4 more years, or we're not, could you please tell us which of the 4 or 5 or 7 Republican candidates will satisfy you if they are elected to do things other than Obama is doing? And also, could you please tell us what the Fox News, the fair and unbalanced
what their position is vis-a-vis this particular problem.
I actually haven't heard enough about what the Republican candidates profess to believe about classification and the laws and the passage of the Free Flow of Information Act, which would protect journalists, because we've been so involved with other issues at the moment, whether it's, sexual harassment or oops, or, I hope we will hear more. On the other hand, President Obama candidate Obama made a great many promises about a more transparent and open government, and all I'm suggesting is that he stick to them and that the people hold him accountable for what he promised. And as for Fox News, its news is labeled news, its commentary is labeled commentary, and I'm the balance in the form of a brunette and an independent. Thank you.
Do you think it's WikiLeaks' responsibility to control what they publish?
Yes, I do, which is one reason why I'm very, very unhappy with what Julian Assange has done. I mean, I've worked with, I've interviewed embassy people. I've worked with a lot of the dissidents whose identities were compromised by what he's done, especially this last tranche of disclosures that just came out without any vetting. That's just irresponsible journalism. And but do I think he should be punished under the espionage law for that? No, I don't. I think people should refrain from using information, responsible news organizations that would compromise the safety of dissidents and people that we should protect.
Well, then what if they're irresponsible and there's no sanction on your view?
Then don't buy their paper, or don't advertise in their journals, or shut them down, which they've now been shut down. They're out of business, and Julian Assange is facing other criminal proceedings about to be in Sweden. So we've solved that problem for the moment, but the next Julian Assange, the next WikiLeaks, I think we're just going to have to learn to live with that, and each news organization will have to make a judgment about what it feels is responsible reporting and not. That's the way the system works.
I have a microphone here, thank you. I hope I'm permitted to ask a slightly different First Amendment question, but I wondered what the panelists' views would be on the recent spate of state laws that are tending to criminalize the videotaping or recording of law enforcement officials in public and then prohibiting publication of that, when in fact the officials are able to videotape us and do what they want with it.
We have a case, so I can't discuss it.
I haven't thought about it, so I can't discuss it.
We have 3,000 cameras in New York now, just in Lower Manhattan. And I think you can't assume anymore that when you walk through the streets of New York, you're not being photographed or surveilled or monitored. It's a real problem, and the fact that I don't like these laws, these new laws. I think if you're going to live in a surveillance society, surveillance has to work both ways, and the media should be responsible for being the people's advocate and getting information out.
I think that's the end of our program. I want to thank our panelists, and I want to thank all of you for coming.